Welcome to another episode of Conduct Detrimental. Dan Lust, joined by my friend, Taryn Sharma. Taryn, welcome back to the podcast. How you been, my friend?
We are friends. It's good to be back with you. Any opportunity that we have to be able to get together and talk about our love for everything at the intersection of sports and law. How lucky are we? Who's got it better than us?
Nobody. That's who. No, Taryn, we have known each other for a while. If you said I wasn't your friend, we would have an issue. I don't know what else you would call me, your colleague, but that's not fair. Reflecting a little bit on life. You and I before we hit record, I had my 5-year-old in here. She's like 5.5 almost, and you and I have known each other basically as long as my daughter has been alive, and I feel like I know her pretty well. So, Taryn, we are friends. We go back at least 5 years at this point.
Yeah, I would say so. Very good friends. You were the best man at my wedding, so
Oh, yes, let's do it. Slash, yes, I was. Okay. Yeah, there's no defamation. It's just, it's all rhetorical, but we will talk about that on the show. Um, okay. So, big shout out to, before we start, St. John's University, number 6 basketball team in the country should they have a big game this weekend against Marquette, number 20, but we had a loss by number 4 Tennessee. So there is a world where St. John's is a top 5 team, maybe potentially a number 1 seed in the tournament, Taryn. I'm excited. I don't think I've ever been this jazzed up about college basketball before the month of March, and now that we're in March, oh boy, things are going to get dicey.
I am a big college basketball fan, obviously, as you know. Love Duke. Uh, I'm seeing a lot of people credit Rick Pitino for this turnaround, and not enough people mentioning that St. John's engaged a certain slick-haired lawyer.
That listen, no one has given me any credit. Not that I deserve any credit, but I appreciate, Taryn, that you are acknowledging that by sheer and utter coincidence that this rise to the top happened in some way, shape, or form around when I started speaking to them. But that is neither here nor there. But I'm happy to celebrate St. John's. We're rooting
I'm
for them
just
in the
saying,
tournament.
I'm just saying, Dan, a lot of talk about second year Rick Pitino, not a lot of talk about first year Dan Lust.
It's the third year Dan Lust, but who's counting? Who's counting? Okay. So, yes, Taryn, appreciate that. We're rooting for St. John's, all the good stuff. We'll root for Duke too. I have no issue with that. And it's all good. Okay. Taryn, we have an interesting podcast today. We have 5 topics. If we get to a little bit more, that's all good. We, in no particular order, you can tell me which one you want to cover first. We're basically about, by the time this comes out, this will come out on Friday, March 7th. We will be 30 days away from that date that everyone has circled in the sports law space, the approval of the House case. I get all these texts, which I'm sure you do as well, of what have you heard about House? What have you heard about House? And I said, there are objectors. They will be speaking on April 7th, and that's really it. So we don't know the strength, of those objectors. We don't know quite what they're going to say, but Taryn and I want to at least talk about it, what's happening. We're 30 days out, very similar to how we were 30 days away from July 1st, 2021, once upon a time. And we sat on this here podcast and we were pontificating about what would happen on April 8th, aka July 2nd. So we will talk about that. An interesting case, another big issue that's come up a lot in the college space, eligibility. I had I won't mention who it is, but I had a father of a Power 5 basketball player call me and said, what's the status with these extra eligibility? Is the NCAA going to give out an extra year to everybody just for fun? Because there's been some helpful case law, or we'll say a harmful case law for the NCAA concerning JUCO players and Diego Pavia. But that's a football player. It's JUCO. It's somewhat self-contained. The case of Dylan Goldstein, a University of Georgia baseball player, will give us some insight as to whether that additional year is going to apply to other sports and non-JUCO contexts. That is an interesting case and somewhat juicy, as Taryn and we will discuss. A resolution to the Clemson, or seeming resolution to the Clemson FSU Atlantic Coast Conference, basically television dispute, and they're trying to depart the conference. We will talk about that. And then outside of the college sports world, it happened right as we were recording last week, and I decided to kick it to this week. The Wembanyama jersey controversy, which is happening right in my backyard in Westchester County, New York. I will not call out the person that reached out to me, but I guess I know one of the lawyers, and it's not the lawyer for Golden's auction. It is the lawyer for this dad who sold the Wembanyama jersey that was given to his young son. Cool. Okay, Taryn, I said 5. I said we were going to do 5. I only mentioned 4. We'll see if we get to the 5th. Taryn, you are in charge. Okay, I'm going to take a nap in the shotgun seat. You're going to take the wheel. Where are we going? What avenue are we heading down first?
Yeah, I think we got a pretty significant update on House this week. I think we have to go there. We got some new information. For those that haven't followed or maybe have only tangentially followed, there's a $2.8 billion legal settlement. It's going to completely reshape how college sports operates. And some 102,000 athletes have signed up to receive damages from this action. And that's only the people that have signed up. Some 390,000 individuals would be covered by this class action lawsuit, and only 343 have specifically opted out. As you may know, if you're listening to this, you're a lawyer or law student, the way that a class action lawsuit works is that people can opt in or opt out of the class if they would be categorized under the qualities of the class. So if it applies to them, they can opt in, they can opt out. And so what this says is that a significant number of individuals have opted in, and they are prepared to receive the payment and basically sign away any rights to file subsequent claims on the same grounds. Did I cover that properly, Dan?
I think you did. But yeah, I think you did, Taryn. Go ahead. You're good. You get the green light.
Yeah. So I mentioned that this is going to fundamentally change how college sports work, and it's going to create essentially a cap system. And so each school is going to be able to pay up to $20.5 million directly in quote unquote NIL cash to its players beginning next school year. And some schools have already announced that they are going to do that. Some schools have already started giving out contracts. So if you think about why that is, trying to lock student athletes into these contracts, we obviously heard the Wisconsin case, which was about a student athlete who signs that agreement. Can they then enter the transfer portal after that? So a lot going on around House. But we did receive this update, and we now have an idea of the student athletes that are going to be maybe objecting to this. So there are going to be objectors that are represented by a series of law firms, including some big ones, but also the United States government objecting.
Can I well, I guess we just pause here for a second. What's the total number? Was it 21? I don't have it in front of me.
Yeah, I believe that's right.
Yeah, so this is the part we want to pause on. Like, we've always said this, and I think the line at the Conduct Detrimental Resorts World and Casino for whether the settlement would get approved, I think we took an aggressive line early with minus 150 when the whole world was saying it was a virtual certainty, and that number has fluctuated. It's gone up, it's gone down. Obviously, once we had the requisite amount of athletes opt into the settlement, or put another way, not opt out. That number has risen. I feel comfortable saying that number is maybe minus 250 as of today. Maybe you tell me it's a little bit higher. But that's for the case to get approved on April 7th. April 7th, as we've alluded to on previous episodes, is a big day. It's just a nice date on the calendar concerning fall sports. It seems to allow for everyone to restart over the summer concerning fall and scholarships and any number of factors, revenue share agreements, all that fun stuff. So, our goal for today is to remind people that there are a number of interested parties to this case. Livy Dunn found her way onto the list. The I guess the press release or the memo that came out when this list came out is that they couldn't afford everybody a spot, as an objector. It's a court hearing on April 7th, so you can't have 100 people and eggshells on Twitter, aka X, speaking up. So they picked their spots. At least one name we want to point out is they've been on the podcast before. Corey and Tillery was the law firm, friend of the show, Garrett Brocious is at, that helped with the minor league lawsuit settlement and class action lawsuit. So you can go down the list.
And sorry, Dan, I gotta hop in there because most notably, Garrett is running the Fontenot case,
Correct.
which is in some ways kind of competitive to this settlement.
Yeah, a number of these parties, we're not going to go through each of them, but everyone on this list in some way, shape, or form has an agenda, and we're picked by the court to represent that particular agenda. Now, I'm sure, like Livy Dunn, for example, is the 14th objector. I'm sure there were a number of athletes that wanted to be on this, and obviously Livy Dunn has a huge profile, so she makes sense, right? But the court's not going to allow us to be a complete sideshow and allow hundreds of people on and draw this out over days and days and days. So this is really the final piece, and you and Taryn, you and I were talking offline, and to the extent you want to talk about the substance of any of these objectors, I'm happy to. Friend of the show, Mark Edelman, the professor at Fordham Law School, my old professor, is very adamant that he believes that this will ultimately face an appeal to the Ninth Circuit. So no matter what happens on April 7th, he thinks that there's no resolution after that. And we'll see. So I know, when Professor Edelman, aka Mark, tells me X, he's usually right. So, the conduct detrimental resorts, world, and casino is whether it will get approved on April 7th. It does not factor in potential appeals and lengthy appeals at that. So, it's a wait and see approach. But I know schools, collectives, all of the above are anxiously waiting to see if this will be approved. And this is the big date on the calendar. There might be another date after that, but this is the date we've been circling for many, many weeks, many months.
Yeah, I agree. And I think I would take the minus 250 there. I do think it's going to get approved. I think that Judge Wilkin is more or less like walked hand in hand with the attorneys on both sides to get to this point. And it's been pretty clear that this is where we were headed this entire time. And I think that we end up with a settlement. And even when we get to April 7th, I think that is just going to be insane, really, because think about it this way. The portal for spring sports, so for college basketball, is going to open on March 24th. It's bad enough that that is happening in the midst of the NCAA tournament. That's in the later rounds of the NCAA tournament. But also, April 7th is, a couple weeks after that. And so I think there are going to be a lot of schools that are saying that they're going to be giving certain contracts. And I would just urge any student athlete that is receiving one of those to just make sure that the numbers kind of stack up.
It's a great point. We alluded to it last week. Like I believe the transfer portal for basketball opens up on the 24th.
Yeah.
And, like these scholarships, monies, it's all relatively in flux. So you just, I'm sure, Taryn, you're the same. I am very risk averse with my clients. I always tell them the best case, worst case. And I've told the parties that have asked me how they should handle this. And I said, you just have to be honest. And, maybe some others in the space will not be as honest and will guarantee certain things will occur. You can't do that. So you just got to be honest. So if we have any school officials, people with collectives, lawyers, agents, we as lawyers have a certain obligation. And other non-lawyers have different obligations. But I would say if you're doing it right, you're avoiding unnecessary liabilities and just trying not to give your brand, your agency, your school, your collective a bad name. You got to just do everything above board, and you'll end up with the right kids that want to be at the school for that right reason. Okay, Taryn, I feel good about House. We'll obviously cover this more as we get closer to April 7th, after April 7th. But if you are not in the college space, this is everything. This is everything that everyone's paying attention to right now. So, okay.
Yeah. I just want to point out real quick, if you are very interested in this space, Our friend of the show, Sam Ehrlich, has created something called the College Sports Litigation Tracker, and we find it to be very helpful in terms of keeping everything straight. He uploads the documents, the court documents, directly to there, and it's a very valuable resource. So if you want to check out collegesportslitigationtracker.com, that's a great sort of central hub to be able to look at these specific documents that are going to totally change the way that college sports operate very soon.
Good shout. And while we're here, let's also give a shout out to Themis Bar Review, the top bar prep company in the entire galaxy. We're getting close to bar time. It is March. You're getting ready for graduation. I would hope that you've already picked Themis at this point. But here's the good news. I've been told. For those that have not yet signed up, I do have a discount code. Okay. But we are incentivized to hear from you directly. We don't like when people just sign up and they don't have a personal relationship with us. So if you are looking for a discount code, I have it available. Reach out. You can reach out. You can. I mean, listen. In this day and age, if you just Google me, you can find my email address online. I'm not a mystery. Don't abuse it. But,
Google me.
I mean, listen. It's public. You can Google me. It's out there. I don't have anything bad on Google. Not yet at least. But anyway, that if you want to reach out, we over the years have been very good to our podcast listeners. I get a lot of outreach. If you mention in your outreach that you are a podcast listener, I find time. And if for whatever reason you have emailed me and I've not got back to you and you are a podcast listener, follow up with me and you have my word that I'll get back to you. Taryn, how's that?
I was once just a listener who messaged you or emailed you or whatever, and you thought I was an old man, and I wasn't.
Yeah, no, I was just like seeing into the future.
I hope so.
Yeah, no, I always love telling that story, but the truth is, and this is just like I was talking to a client yesterday. He was asking me, "Tell we're going to go to memory lane for a second before we do some college sports stuff, because just doing college sports stuff that's no fun." And Taryn, me and you are at our best when we are talking about sports. We're talking about love, but we're also giving some career advice, some life advice. So I had a client in asked me yesterday. I guess I won't ask the specific thing because then he'll know I'm talking about him. But essentially asked me, what's the difference, from your day to day as I'm turning 37 this year versus when we started the podcast in 2019 when I was good at math here, 31. And I said, once you have kids and, you move up in the firm, you have more obligations. It's like very tough to balance all this stuff. So Taryn, you and I met when I was just getting started out and you were just getting started in your career and everything synced up and with all good intentions. And Taryn, you're going to feel this as well at some point in your career. Like you got a lot of time before you have kids to speak to as many, sometimes it's, prospective clients. Sometimes it's law students, I don't know. Sometimes it's college friends. Like, it just things change over the years. So, while you have free time right now and you are sitting here listening to this and you could be 25 as the individual who asked me the question yesterday, but if you don't have kids, you're not married, you don't have a house, you don't have a mortgage, you don't have this stuff to worry about. This is your time to really do a overhaul on what you want your career to look like. So I'm happy that, I laid the foundation when I was in my 20s to get to here. And that's what anyone in their 20s should be doing. And if you're older than that, we've talked on the show about lateraling and all that fun stuff. But yeah, so I'm happy. Shout out to Bryce Goodwin. He's arranging the Conduct Detrimental Symposium with his whole team. I love that Conduct is still running fierce. There's a huge network of people here. So if for whatever reason you don't want to reach out to me, Taryn, you're a fantastic resource. Mike Kravchenko. We got a lot of people here, and our network is continuing to grow and grow and grow. And it's all good. Okay, Taryn, I've gone down memory lane enough. Are you ready for your next real topic?
I can.
Okay. Taryn, can I ask you this? I think I can ask this. I think this is fine. I don't think it's inappropriate. This is when people's ears perk up and they're like, oh, Dan's about to get canceled again. You ready for this? Okay. So we referenced. Let's do, you're good with doing Dylan Goldstein here?
Yeah.
Okay. So Dylan Goldstein, a baseball player at the University of Georgia. He is a postgraduate player. That's a player that has graduated at one university and is playing basically as, you call them a fifth year, but they're still technically, they're getting their postgraduate degree. It's not that complicated, but they're still technically eligible to play for the NCAA. So that was prior to all of this stuff with NIL and the transfer portal. That was short of a redshirt exception or medical exception or waiver, something like that. that was really your way to get a quote unquote fifth year, an extra year of eligibility. I don't even want to call it fifth year, an extra year. That's if you graduated from one school, you did not have to sit out a year in the transfer portal. You could basically go to any school you wanted to. They accepted you for the post-bac, and you could play for their team. Obviously, some exceptions, but broad brushstrokes. So in this climate of NIL and transfer portal, I don't know, kids are getting extra years left and right. There's the COVID year. There's everyone applying for waivers. And as I referenced at the top of this podcast, there has been litigation, specifically from Diego Pavia, a quarterback that played at the junior college level, that basically petitioned to court to get an extra year of eligibility based on his time at junior college. So that begs the question: if we're going to give extra eligibility to a player because he, I don't know, played at junior college and he played football, what does that say to baseball players or basketball players and this and that and the other? Okay. So Dylan Goldstein is a baseball player at Georgia, is in this scenario, applies to a court, and Taryn, I'll pull up the specific court momentarily, but essentially petitions the court and says, and asks for emergency relief, and essentially says, hey, I'd like an additional year of eligibility. The season's about to be over. I want to figure out what I'm doing at the portal, all this fun stuff. Taryn, I'm going to kick this to you while I pull up the fun stuff. Taryn, what is the result of that application?
Yeah, Judge Self determined that Goldstein had not adequately shown a viable antitrust claim because he couldn't establish that he was going to miss out on any sort of NIL deals if he wasn't allowed to keep playing. And in response, Goldstein's attorney filed a motion that was asking that Judge Self vacate the order because
don't say the good part. Don't say the good part yet.
Okay.
So we're in agreement.
Well, I would say he was somehow biased towards the NCAA.
Correct. So, okay. Got it. He, declined the case. That would be the first time, a judge has been asked to recuse himself. Okay. Interesting. Right. We obviously would bring this case up in any event. Where the bias occurs is, I think, the really interesting part. I don't know if he was the first to say it, but friend of the show, Tom Mars, has a tweet that I'd like to read. And this is where I think it originated from. And if I'm wrong, I'm wrong, but this is where I saw it first, at least. So Tom Mars, he's been on the show a couple times talking about particularly the COVID football season cancellation, but he's a heavy hitter in the college sports space. This is his tweet. Federal judge whose X profile says he is a, quote, NCAA football official departs from recent federal court decisions and rules for NCAA in case brought by player seeking to extend eligibility. Judge served as an NCAA official as recently as November 2024. Okay, people start looking back. We see Tripp Self is the judge, and on his, I don't want to say it's his, but someone claiming to be Tripp Self says, his bio says husband, father, United States District Judge, NCAA football official. Okay, interesting, and it says Macon, Georgia. So people who did their sleuthing, okay, and the sleuthing seemingly, and again, everything is, we'll say reportedly, allegedly, because we're probably going to talk about defamation on this lawsuit. Reportedly, allegedly, his account, okay? And even if it wasn't his account, Tripp Self, the sleuths on the internet, seem to have found evidence that he has been a longtime official. The earliest date I saw was 2017, and if you're listening to Mars, he says as recently as November 2024. So assuming he served that entire period of time, that would be 7 years as an NCAA official. I think he served on the 2017 FCS National Championship game with James Madison. So this is a judge who is an NCAA referee. Taryn, I want your analysis on the overall point, but would you say, and also I think we should point out, Tripp Self is reported to have been a graduate of University of Georgia Law School. So he has ties to University of Georgia, and he has ties to the NCAA. So I could make the argument that, yes, he's probably biased for the NCAA, assuming that to be true. And if this eligibility request was to have the kid play another year at Georgia, I maybe make the argument he's biased both ways. Taryn, now we are here. Do you think this is a fair objection? And the question is, why this was not brought out before? Maybe it was. I haven't seen that. But do you think this is a fair objection on a bias consideration?
I'm not sure that he's biased towards the NCAA in a meaningful way. There's no record of him ever being directly compensated by the NCAA. Officials are basically part-time independent contractors that work for different conferences. And while they're assigned to work in a certain arena on a certain day, they generally have control over their own schedule in terms of picking up games. I understand that he did that 2017 national championship, but again, sometimes in bowl games, you notice that they'll say, uh, and tonight's officials are from the ACC or the Big Ten, right? It's generally intended to be a conference that is not the conference that either of the teams belongs to, and he's predominantly identified as being a official for the SoCon, not the Southeastern Conference, but the Southern Conference, and so I think that it's a little unfair, and I would see it even the other way if the NCAA said, "Hey, this guy went to Georgia, and he's a district court judge in Georgia." Of course, yeah, it's likely that he would have gone to the largest law school in the state. So, no, I don't buy the argument. I think it's just trying to be creative to get around the fact that they lost.
Sportico is reporting that they, at least from their review of the docket, we don't have access to the Georgia docket, that from the time the litigation began to that time of that decision, it doesn't appear, for at least from Sportico's article, that there was a recusal motion made to have the judge step down. In this, I don't know. I'll say normally you're supposed to research the judge. Apparently, on the judge's public profile with his honors and awards, this is readily discernible. So we're not here to play the blame game, but I am surprised that something that big would not be caught on a case that serious, especially right, like Taryn, to the point that you just said, like the Georgia conflict definitely should have been figured out. Like probably most judges in the state of Georgia went to Georgia. So if you have identified that conflict, which I'm not sure if they made an issue of or not, I would think you would go this step further to read his full bio to see if he has any other conflicts. So I think it's interesting. We're bringing it up just because it's such a unique thing that happens. And obviously these emergency relief, I think the application was filed February 18th. So it's a really tight turnaround for these motions. So you don't really have the full ability and full breadth of resources to research a judge. And, it's just kind of who you're assigned at that particular time. Like it's possible they saw this issue and they said, you know what, instead of having a recusal order and pushing this back another week, let's not say it. Like, I don't know. If the attorneys want to say that, that's their prerogative, but certainly possible. But anyway, that's where we are. We're still very much in a gray area. And Taryn, to the initial point before we got lost in the recusal piece, the application was denied. So if you are a baseball player, maybe if you are a Taryn, to the analysis you spoke about earlier, if you can show that you have a contract in place, for that extra year, and you will lose NIL opportunities, specific tangible ones that are tied to a specific contract, maybe you should refile the case. It doesn't seem like this is, applying application or applicable to all baseball players. But yeah, I mean, it's just kind of a wild world that we are still in. I'm not calling it the wild, wild west because we are getting closer to some rules, but this eligibility issue is a real problem. Like, imagine if you have to, right now, if you're a basketball player, you have to decide whether you're going to try to transfer or you're going to try to fight for a fifth year. I don't know. If you're a parent of a kid, it's just such a tough decision right now.
Yeah, and I wonder if as we approach House's settlement being finalized, whether just saying like, hey, colleges are going to have up to $20.5 million. Here's how much we anticipate is going to be allocated towards baseball. There's a reasonable opportunity that Goldstein could get some piece of that. I wonder if that is enough of an argument to show that there's some viability to at least let the injunction go forward.
Agreed. Okay, Taryn, let's do FSU, and then I think we'll see if we have some time for the next two. But Taryn, do you want to take the lead on the we'll say impending resolution in the FSU Clemson ACC matter?
Yeah, this is one that David McKenzie, who is a Duke guy, If you follow him on Twitter, he is a great follow. He's been really in the weeds on this. But just as a high level, Florida State and Clemson, and North Carolina to a lesser extent, are unhappy about the way that the ACC has operated in terms of television money and expansion, specifically including Cal and Stanford and SMU, as they did during this most recent round of conference realignment. And so Florida State and Clemson have both filed suits that are going after the ACC, specifically the amount of money that it takes to exit, the so-called exit fees. So that that litigation by both Florida State and Clemson has now been settled, and so there's peace in the ACC at least for now. Essentially, what is going to happen is that the exit fee is currently $165 million. So they're putting a real number on it. There was thought that it could be, some $700 million. Would they be able to take their television broadcast rights as a result of having signed the grant of rights agreement? And so now 165, way more palatable. And then that number is going to decrease by $18 million year over year through 20, and by the time it gets to 2030, 2031, that number is going to flatten out at $75 million. So way more reasonable than what was expected. And if you pay the exit fee, then you can leave with your media rights intact, or at least that's our understanding of the settlement. So that $75 million, way more reasonable than $700 million, even more reasonable than $165 million. So kind of sets the stage for another round of realignment in 2030. If you think about the television deals and where we're at right now, and obviously so much of this is subject to change with the way that people consume television, and whether that's going to be in some sort of cable form or if it's going to be ad hoc a la carte packages as it is right now. The Big Ten, their deal expires in 2030. The Big 12 deal expires in 2030. And the college football playoff is probably going to change in 2031. So this 12-team playoff that we have right now, it could be expanded. We could see, who even knows if the NCAA is around by then. I think that there's going to be a real power struggle between something that we've mentioned on this program, but the Power Four conferences have formed an LLC, and so maybe that is in charge of college football writ large. And if we're in that situation, we could see even more turnover. So the timing is interesting. The reduction in dollar value makes it more likely that we see some sort of reorganization. And just from a personal standpoint, I grew up with the ACC, the original ACC, and I remember even when Virginia Tech and Miami and Boston College joined, and that even seemed to be a coherent group. But then you start to lose Maryland, and it seems pretty clear that these other schools are going to leave as well. And that makes me sad because I love the ACC. I love the ACC tournament in Greensboro, and just kind of stinks that it seems like there's a real expiration date for it now.
Yeah, I think it's happening. Taryn, before I go completely off the rails, do you watch South Park? Because I have a weird analogy for you.
Yeah, a little bit.
Like, I used to be very big in South Park, not as much anymore. I always listen. There's some jokes you can tell on the podcast, some jokes you can't tell on the podcast. Let's just say there is a South Park episode where I'm kind of too far deep into it, but I think I can say it if it's a South Park episode. Is that fair, Taryn?
Yeah.
Yeah, you have no idea what I'm going to say, but it's okay. It's an episode of a show, whatever. In the concept being, and I'll land the plane. Don't worry, we'll do a little bit of a weave here. But
Mhm.
uh, e- we are approaching a world. It seems inevitable that we're going to lose conferences. We're going to lose these conference rivalries, which we've already started to. We're going to have this weird, we already do have it, right? We have the California schools coming in and playing in the Big Ten. When you have New Jersey, it's wild, and we haven't spoke about it, but there was forfeitures relating to. Taryn, I'm not gonna. You probably know the school. What was the school? Was it the women's basketball team that didn't go play in California during the fires? Did you see that?
Northwestern.
Northwestern, right? Like, okay, maybe like it makes sense that Pac-12 schools were all at one point similarly affiliated and situated by the same coast, so they all had the same issues. But now, like an issue affecting the California fires is impacting Northwestern, and now obviously impacting Rutgers. So the traditions that we've spoke to about normal conferences and normal rivalries are being thrown out the door. Now here's the random analogy where my brain went to from South Park. And Taryn, you can tell me if this is completely a wild analogy, but we already started this, and I don't want to make Mike edit this out. There's a crazy South Park episode where they like go 1,000 years into the future, and like if you walk around the streets of New York, it's a cosmopolitan of people of all different appearances and height and weight and this, and everyone looks different. But 1,000 years into the future, South Park predicted that everyone would just be homogenous and look basically exactly the same because for whatever reason, we don't need to get into it, but like we lose that a little bit. If everyone like when I wake up every morning, I look at the college basketball standings. I like sorting by conferences, right? Like, or I like seeing who's winning the Missouri Valley Conference. I like going through that, and then I like to look at the top 25. But like top 25 is all the best of the best from each conference. But as we start to lose more and more of what makes these conferences special, we're just going to have one giant, top 100 list, so to speak. So that's my fear. I think that's what's so nice about college sports. And again, we are obviously very pro change and all that fun stuff concerning NIL and players' rights and school rights. But you do lose that, and I think anybody on either side of the aisle is kidding if they are saying that nothing is going to change in college sports, because it is and it will, and um, that's why we're here. But we love it. And Taryn, as you and I, two people that are involved in the NIL space, I think it's good to have people like us who are traditionalists and being involved in trying to help shape the future in whatever minimal way we can.
Yeah, I mean, you'd like to think so, but ultimately, those decisions are made by people who do make decisions based on dollars and cents. And I agree with you that I think that having local flavor to the conferences is important, is valuable, it's fun. I like that we used to have Pac-12 After Dark. That was really fun. It was a great showcase for those schools in those particular places. I really enjoyed that the Big 12 was like so focused on offense and it had more air raid systems and just had a different feeling. And I agree with you that if we are continuing to head towards something that is more homogenous and everybody kind of plays the same and everybody uh, is in one big super league, which is another thing that we've covered here. I think that that is something that is cool about college sports that gets lost.
You
And it's something that you can see in professional leagues, right? Like the AFC North plays a certain way, but it's so much more rare than what we had in college where it happens just organically.
agreed. Taryn, at one point you said cool, and you sounded a lot like Stewie saying "cool whip," but got to keep you on your toes. Okay, let's do this one quick. I'm getting the call from my wife that I have to start to get ready to watch the kids, which is great, which is fantastic. But we find time
Mhm.
to get this in. Speaking of people making decisions for money, Victor Wembanyama jersey swap. I'll do this one the broad brushstrokes. This is a case again filed in my backyard over here in New York. So it's made a lot of news right around as we were recording the podcast last week. So essentially, there's a picture that goes viral of Victor Wembanyama doing a jersey swap with a young kid, Taryn, in Brooklyn, right?
Yeah,
Yeah.
in Brooklyn.
So I think we can get the names.
The photo went viral. It was adorable. 5-year-old boy. He was wearing a Victor Wembanyama, the black jersey, and Victor gave him his like whatever they call it, City Connect or City Edition jerseys.
I'll plow through this quick, and then we'll see if we have time for our fun topic at the end. But the father of the young boy, so I guess that's Frankie Desidere Jr. Um, so that's the son, and then senior is the dad. Basically goes, which I don't really have an issue with. I mean, listen, for the love of the game, whatever, but it's really expensive. They basically go to Golden's auctions, which um, they are a very big auction house, and they do some deal, and I don't think the terms have been released, but essentially there was going to be they're going to receive a proceed of the sale, and from what my understanding is, as the dates line up, post jersey swap, but before the so obviously when they had the jersey swap, Wembanyama was playing and was healthy. He's obviously out for the year now with blood clots. By the time the auction closed, which was last week, Wembanyama had gotten hurt, which should probably impact the value of the jersey, right? If no one's sure what he's going to, if he's going to play next year, it's fair that would harm the value of the jersey. So, according to the filing that's done in New York State Supreme Court, Westchester County, right by where I live over here in New York, they were contacting Golden's Auctions to pull the sale. Golden's Auction wanted to keep moving it forward, and then there's like a remember the tearing the mailbox rule in contracts.
Yeah.
There's some element of that here where they filed this temporary, this I don't want to say it's a TRO, but this application in Westchester County to stop the sale, and that's filed before the auctions closed. But Golden said they didn't see it, this legal filing before the auctions closed. So by the time they respond in court, which they have at this point, and the dad seems to be, at least from his initial filing, representing himself pro se. Golden said, "Hey, listen, we sold the jersey. It's too late. We already shipped this thing out. The auction closed on a Friday. We signed, sealed, delivered. We packed this thing up. We sent it out. Money's been paid in within 12 hours. So tough luck. You can't get the jersey back." So, I might have to third party in the guy that got the jersey, but I think we are long past that. And again, buyer's remorse in very limited instances, that's going to be a real defense in court to unwind a sale. But to the extent that the party did have notice beforehand, you do maybe have an obligation to pull it. If they had noticed beforehand and there was some real reason, and Golden saying in their filing that they did not have notice, which is their position, but there's no real impetus to sell or to have it done in that auction as opposed to a later one. The father here is claiming duress and that he didn't want to sell, and he told him he didn't want to sell, and they made him go through it anyway. I'm not sure any of those are valid defenses, but yeah, by nature of the fact that a jersey is sold, a 5-year-old cute little kid is involved, and a dad who wants to maybe pay for his kids' next couple birthdays in summer camp, it's got our attention, Taryn.
Yeah, absolutely. I think it's sad in that Wemby thought that he was doing something nice, and then he found out that it was for sale and quote tweeted it that with the crying emoji. So yeah, I get it, but I don't know that this is going to be a successful claim.
Okay, so Taryn, I will say this, and I think we can. Taryn, do you have a what to watch for before I say my piece?
Yeah, absolutely.
Okay, let's do a quick what to watch for. I'm getting the old like hook to get pulled off stage. Give me your what to watch for. I'll say our final words, and I'll call it a day here.
Yeah, my what to watch for. There's finally been a settlement in the Nationals Masson case with the Orioles. Long story short, Masson was founded in response to the Nats moving from Montreal as the Expos to DC as the Nationals. That market was owned by the Orioles ever since the Senators had left to go to Dallas and become the Texas Rangers. And so that arrangement was not particularly profitable to the Nationals because the Orioles owned 90% of it, and that percentage was that the Nats could own was capped at 33%. So they were always kind of playing with one hand behind their back, and I think that it's affected their ability to sell the team as well because there was no sort of clarity as to what will happen. There is clarity now. So the Nats are going to be on a 1-year deal essentially with Masson this year. and then next year they will be free to sell their television rights. I think that the Lerner family has wanted to sell the team for some time. They've been dealing with some health issues as well, personally, but I think this kind of opens the door for that. So I wouldn't be surprised if we see the Nats get sold in the next year or so.
Okay, Taryn, I like it. We'll keep this really tight. I always try to give you recommendations of sports when my wife also is really into it. Running Point, the new show with Kate Hudson.
Oh yeah, my mom loves it.
Yeah, well, listen, it's popular in the Lust household. We binge that thing in like a week. So, if my wife watches it, who does not like sports, I will tell you that you are both sides, both spouses or significant others will likely enjoy it. Okay, Taryn, I'll say this as we get out of here. April 1st is the Conduct Detrimental Symposium. It's on Conduct Detrimental's LinkedIn account. I shared it on my story on Instagram, but you can just go to either my LinkedIn or Conduct Detrimental LinkedIn to get details. April 1st. It's going to be a sports media centric symposium. Okay, Taryn, I made it. Made it by the deadline. Okay, Taryn, you good? You good?
I'm great.
Taryn, you're the best. Next time, I want you to be incredibly inappropriate. You were well to behaved for this podcast, and listeners have come to expect you to be wildly inappropriate. So you'll make it up next time. That'll do it for here at Conduct Detrimental, and we will see you next time and next week on another episode of Conduct Detrimental.